All right, so here it is. So what happens is the following. Arbitration, the way it's done at the state level, it's done at the federal level, and the same way at the international level. When you go to adr.org, the page on it says ICDR-AAA, right? Or AAA-ICDR. Who here has never seen the AAA's page, the American Arbitration Association's main page?
Same.
So the page says AAA along with ICDR, which means International Commercial Dispute Resolution, which indicates that it can be used in the United States as well as internationally, right? Anybody disagree with that logic? I know it to be true. I'm just saying, just to save time. Okay, everybody became a mime. What are you guys doing? Making boxes with your hands? What are we doing?
Listening.
Nikia,
Yeah.
you busy?
No, I'm listening.
All right, I'm gonna bug you all day today.
Why would you do that?
Why would I do
All
that?
right, let me see.
All right. So here, okay, can you go to the top real quick? Okay, not all the way to, well, yeah, let me, yeah, right there. Making myself a coffee, disregard the noise. All right, so number one, it says provide an agreement to arbitrate, right? Avoid insufficient detail, do not overreach. What does that mean?
I don't know.
Well, first we got to have an agreement in order to be able to arbitrate, right?
Okay.
An agreement to arbitrate. Okay, the second one is considered a tiered dispute resolution. A tiered dispute resolution means like there's tiers where you could have, let's say, okay, compulsory negotiation or mediation. Now, there's a difference between mediation and arbitration. Mediation allows for a referee pretty much to step in and make sure that they can fix the contract before the contract is considered broken and you now have to submit to arbitration. Now, number two says consider that. Does it mean we better provide it?
No, just to consider it.
Yeah, so then that means that, what if I want to say, I could give a fuck less about renegotiating what you breach? Contract's a contract, God damn it. Can that contract that I'm drafting and that we're gonna agree to be in such a brutal fashion and format as it is created? Or do I have to give them that opportunity? Secure.
I don't know.
Not if it's already built into the contract.
Huh?
If it's already built into the contract, if it's already built into the contract, that
The answer is I don't have to give them grace for nothing.
Right, because it's
That's
already in
what
the
the answer
contract.
is.
They already understand what's going on.
That's it. So I can consider it or I don't, but I don't have to do it.
Okay.
Now, if we go down to number three, it says, describe what can be arbitrated. The issues to arbitration. Okay. So what are we going to arbitrate in our cease and desist? How about their lack of performance? As a result of gaining a benefit from our asset, they failed to perform accordingly. So they accepted the benefit, but they didn't cease and desist. And destroy all property and blah, 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 that would be infringing. So we've read the cease and desist, right?
Yes.
So the cease and desist pretty much tells them, if you want to continue gaining the benefit of this, these are your tasks to handle in the cease and desist. You must destroy all infringing articles. So they have a license to sign off any document that would stop the proliferation of our trademark. That is how they are allowed to use our trademark. So if they don't let go of a case or of the file of the case or take it off the record, then they have breached for lack of performance. Now, 4 is select ad hoc versus administered arbitration. You ain't got to worry about that. Go down to 6. I mean 5 and 6. Okay, so when you select the arbitration on number 4, just pretty much all that's saying is select the AAA, right? But 5, pick an administrative set of rules. And then you got to specify the law governing the provisions. Now, this really makes it hard. Why does it make it hard? It really makes it hard only to look at, but it's very easy to understand if you understand the statutes that are presented for you. For example, substantive law. What is substantive law? Substantive law is supplemental law. Raymond, we don't get what the fuck you mean. All right, check this out. Let's say I live in one state, right? And I want to sue somebody in another state. I got to do it in federal court. So I got to use federal law and federal provisions to get my ass into that court so I can sue somebody else in another state. I have to use federal venues. So because we're dealing with interstate commerce, and we're also dealing with arbitration, arbitration localizes us to each other due to contract. So that we don't need to have all this hubbub about standing, because we both have standing as parties who made a sense to the agreement. But we do need substantive law in our contract because we need a law to support our actions and our lack of action that quantifies the law of our agreement. What choice of law do we use in our agreement?
Wouldn't it be, is it Unisatol?
No, the choice of law. What is the law that we use? No, what is the law that we use to activate arbitration?
It would be trademark infringement, Lanham Act, right?
No. There's, no, it's written on there. Come on. How about 9 USC?
11,
9
17?
USC? 9 USC?
No.
Huh? 9 USC. What does 9 USC control? 9 USC section 1 through 16. But what does it control? Well, okay. I want somebody but Kiara to look it up real quick and put 9 USC section 1. What does it fall under?
USC what?
Section 1.
1. Oh, maritime transactions. Let's see.
It falls under what act of law?
Federal Arbitration Act.
There you go. So the law of our contract is going to be controlled by the Federal Arbitration Act, right? Because it's an alternative dispute resolution type of contract, right?
Yeah.
Mhm. So what would supplement our ability to show a breach of that contract so that arbitration could be activated? Well, what would supplement it would be the terms and conditions of the contract and the reasoning behind the contract's creation. For example, we are going to go to arbitration if anything happens wrong with that contract. But our contract is regarding, why did we make the contract? What's it over? What's it about?
Trademark, copyright infringement.
Trademark, right. So we need supplemental law to quantify the injury of not upholding that contract, which is controlled by arbitration. So we would need substantive law. Now, what happens when somebody fails to perform correctly and makes a benefit over our trademark? Where would that fall?
Assumption?
Huh?
Assumption
No,
or
no, no.
unjust enrichment?
No. What would, where, okay, they would be violating, you got 3 statutes right there.
Takings clause.
No, you got 3 statutes right there. And by, substantive law. Which one of those statutes do we use for trademark infringement?
And we used 1117.
Okay, you got to start with the beginning. What's the beginning
Okay, there's
portion?
5 U.S., 17
No.
U.S.C. and
15
No.
USC.
15 USC. Right?
okay, well,
So if they did it willfully, we would attach 15 USC, section 1117, because you bitch ass motherfuckers did it willfully, so you owe me up to 2 million and 3 times those damages. Right? Treble damages. And we could put that on a complaint. Correct or incorrect?
correct.
And the substantive law is supplemental to quantifying the breach of our 9 USC controlled contract. Does that make sense now?
Yeah. So
Who-
basically,
Who knows laws?
So the choice of law is the Federal Arbitration Act, but we need substantive law to initiate the act, which is showing some type
No.
of violation.
No.
of some-
Well, no, you're close. You're close. Look, we got an agreement to arbitrate, period. 9 USC. That's the control of how we're going to resolve this agreement. But because we're dealing with trademark in our agreement, because our contract is made about trademark, then 15 USC violations will support our reason for a 9 USC section 1 action.
That's
Does that make
basically what
sense?
I'm saying.
Does that make sense?
Yeah, it makes sense. It's
So
basically
let's say-
justifying our contract that we can actually put that kind of provision in our contract. And then if they
It
violate it,
quantifies, not the resolution and the control and the law of the contract, it quantifies what the sums of the breach are.
okay, yeah,
So the substantive law acts as an additional measuring stick. Does that make sense?
yeah,
Arbitration
statutorily.
law of the Federal Arbitration Act. Do we add that? Yes, right. We're looking at B now. What law is that? We just said it.
15
9
USC.
USC?
Nope. 9 USC controls the arbitration, right? But our
Okay.
substantive law
Mhm.
will be codified in 15 USC and other fucking laws like constitutional or whatever the hell.
Okay.
Now, what about
We're talking about
statute of
arbitration law.
limitations? Well,
That depends on-
if we notice the breach, we might have only like a year to 3 years to activate that arbitration. That's why we always do compelled arbitration, because the minute that they don't let go or lay go the ego, their heads roll. Into an egg roll. right? So what would that language look like? Let me put it to you in plain Swahili. It'll look and sound something like the following. If you bitch made motherfuckers fail to fucking control the goddamn trademark, then you're in violation of this agreement, which is controlled by 9 U.S.C. section 1 through 16, and all terms and conditions of this contract as applied by, applicable, all terms and conditions of this contract, which can be handled at 9 U.S.C. section 1 and at the AAA, right, American Arbitration Association, under the commercial rules of arbitration. You will be in violation of this agreement, and those charges look something like and can be valued at, according to this agreement and federal and state and statutes of law, like trademark infringement under this, that, and the fifth. You'll waive sovereign immunity under this, that, and the fifth, and you'll freaking be liable for this, that, and the fifth, because it will be considered a willful infringement. Now, that's a really rough draft. But do you see how that sounds like terms and conditions of liabilities in the event that there is a breach of the contract, but you are making a dispute resolution, so you must agree that to breach, it means they're liable for the following. Does that make sense?
Yeah.
All right, 7. Who defines procedures for the appointment of arbitrators and their service? So yes, you do have to choose number of arbitrators. Neutrality of arbitrators may need to set the arbitrator fees, which is loser pays all. Qualifications of the arbitrators, they must have at least 10 years of trademark arbitration experience. We don't want a loser who's gonna fuck up my contract. And let's see, and can the arbitration proceed or start over when one arbitrator ceases to serve? Under what timing and conditions? So there might be an arbitrator who'll sit there and be like, whoa, this contract was made by Satan himself, along with the kiss of the whore of Babylon, and somebody's going to get absolutely wiped out of their bank account. And this looks unethical as fuck, yet I can't find any reason as to why I would want to be a part of this panel. And they might want to go ahead and skirt off to the black. Or he could get shot in his head because the guy you're arbitrating against is a mafioso who owns fucking so much property in Midtown Manhattan, and he has enough bullets for enough heads that choose to think. Does that make sense? The arbitrator might just disappear himself. And this coffee's good. All right. So 8, consider related parties and cases. Third-party claims, joinder of third-party respondents. Are claims by or against parents and affiliates covered? Consolidation permitted of other cases subject to arbitration? Well, if you have a clause in your contract, let's see if we remember this. A clause which states that you're incorporated because I said so. And they're in another case trying to raise havoc. They may be compelled to arbitrate due to what type of clause?
No contest?
Nope.
Incorporation
by
Reference.
reference.
Assumption? Oh, okay.
So all you trustees of this certain sect and all your subcontractors, even if I don't know who the hell their name is or whatever, if they're talking about this contract, then they stand to gain from this contract, and they too will be beheaded, and their heads will roll into an egg roll. Okay. 9, define the process for interim or provisional remedies, if any. Can you scroll down? Please, Kiara. All right. So court versus arbitrators, especially in trademark cases, AAA optional rules for emergency relief. So here's the deal. You can put into your contract, and upon the breach of this fucking agreement, you agree to a court order of injunctive relief until the proceedings are over. Because if one of us got a problem, and let's not continue damaging each other, does that make sense?
Yeah.
We're gonna
So you can
bypass.
build that.
We're gonna
the contract
bypass
with-
10. Good.
You can build it
Okay.
into your contract for interlocutory
Hell
relief.
yeah. All this shit. This is how tight you can tie the plastic bag over their head.
So basically, with that in your agreement, the moment you got your motion to compel arbitration, you stepped into an arbitration agreement or
They want to
arbitration
know how
proceeding.
tight do you
would
have
issue-
them.
they would-
Good.
What I'm saying is they would issue your injunction before the proceedings they even started
Within the
taking
first
evidence.
5
basically.
days. Did we not see that in the Nike versus Mischief case?
Yeah.
They said preliminary injunctive relief. There's not enough adequate state remedy because if these parties continue, they'll be able to damage us and further spread our mark on those Satan sneakers. Huh? All right. So here's the deal. We're at 11, right? Place of the hearing, AAA. Select language, English. Consider consent to proceed with an ex parte hearing when a party having notice of the hearing fails to appear. That means if you are compelling arbitration in your language of the arbitration, you must tell them. If you don't get your bitch ass after being served the word that you must appear here, arbitration will still continue in your absence, and a default judgment may be rendered for your lack of appearance, and you agree. Number 14, select evidence rules. 4 corners and exhibits. That's the evidence. Document filing only, no oral arguments.
Yes, sir.
All right, now let's go down. Define discovery and discovery management. Document filings only, no oral argument again. And according to the commercial rules of arbitration. Commercial rules of arbitration is a rule system in the AAA. There's whole manuals that you can download from adr.org. Okay, specify form award, bearer standard, reason, findings of fact, and conclusion of law, baseball, high-low bounded. May the arbitrators award attorney fees? Yes. May the arbitrators award prejudgment interests? Yes. May the arbitrators award multiple punitive damages? That means treble, right? Yes. May the arbitrators award injunctive relief? Yes. Define the currency for payment of the award. Dollars, motherfuckers, dollars. Provide for entry of judgment and enforcement. See what I'm saying? Let's bypass those 2. It can be held at your arbitration place, but then you can take it into a federal court and get a writ of execution just for docketing the judgment.
Yes.
24, define review provisions, if any. And award is final, binding, and not subject to appeal. 25, award subject to interest payments or other penalties from award date. So since you've been benefiting from this day, according to this valuation, you owe me back payment. And then number 26 is the big one. Confidentiality. We want confidentiality of the proceedings. We want confidentiality of the evidence. And we also want confidentiality of the award. Now, why do we want confidentiality of all of that?
Saves them some embarrassment.
Saves them embarrassment. Do not, I repeat, do not, hold on, give me 1 second, guys. Hey, you know there's like still chicken and all this other shit, right? All that you can kill. All right. Yeah, so what you call it? So that is what we want. We want to save them embarrassment because it allows us to tickle their kitty, have them purr, and then they give us what we want. Excuse my Swahili. When, okay, 27, when, consider devices to expedite. That means we control the time. Did you guys see in your arbitration agreements that there was a time threshold for the arbitration to happen? Huh?
No, I
Huh?
didn't see it.
Yeah, there's a time. Tells you 120 days. And it even talks about 15 days for this in the proceeding, 10 days for that. It does. All right, now, waiver of sovereign immunity. We must put a clause that says, you waive sovereign immunity. What would be the substantive law over trademark infringement for them to waive sovereign immunity?
Willful and inadequate state remedy.
That's substantive law in the case law. That's correct, right? Allen v. Cooper, and what else?
I don't know, what was the question?
Huh?
I'm not understanding the question. I guess I'm not understanding the question.
You got a dumbbell? Were you flexing? Is this what we're doing?
No,
Couldn't
I'm
hear
asking
me.
you, what was the question?
All right, check
I
this
just
out.
said I answered your question. I just didn't understand it. So what's the question?
Would we not, what is the substantive law for waiver of sovereign immunity? You mentioned two, that's correct. There's all, now you gave me case law right there through, because I know that it translates to case law and the requirements under Allen v. Cooper. But what is the
Would it be the statute?
statutory law?
Okay, then it would be 15 USC.
15 USC 1122. That's right.
22. Okay.
Now let's scroll down. Consider specific IP provisions, right? It says, but let's go down. Okay, so specific IP provisions. But what that is talking about is patent with the 35 USC. What we're talking about is trademark. So disregard that last section, but consider the specific IP statutory provisions. Now, what have I said about 15 USC all the other times we spoke, and you have your answer for the list that goes in that spot. Make sense? Hello? You guys are gonna make me cry for loneliness.
Makes sense.
I'm already crying. It's too late. Hey, so what did we learn today?
I guess how substantive law relates to our contracts and initiating
Right, so you can
arbitration.
build them into your contracts, right? Right? Guys, you guys got to talk to me way faster. I'm like, I feel like abandoned. I'm
You're
crying.
just too hyper.
Well, blame it on the caffeine. So we get that this is the way that we're supposed to. We get that this is the way that we're supposed to construct our contracts, right? With arbitration clauses and shit like that, right?
Yes.
Time, substantive law, controlling the proceedings, maybe some supplemental case law and things like that to quantify the specific breaches and performance terms and conditions into our agreement. Now, most of the time, people look at that stuff and they're like, well, why is there so much law in the contract like that? And is that correct? Because a lot of times when we see contracts, they're written in plain language. Yeah, you know why they're written in plain language? Because a lot of people have a team of lawyers behind them that know how to take those plain words and turn it into a mathematical, quantifiable computation so that they can present it for arbitration and the breaches thereof. Due to the four corners rule, it's about what's in those corners. Does that make sense?
Yes.
Yeah.
So the more we specify what the damages look like, the more notice we gave to the parties who intended to breach prior to. Does that not make it look more willful?
Because you can get them, you told them everything up front.
Yeah, they can't even sit there and say, oh, I didn't know. I didn't know that this would be $2 million pursuant to Title 15, Section 1117. I just didn't know. I thought we were immune. You don't see the waiver of sovereign immunity? You don't see the opt-out clause? And it told you specifically in the agreement that it will be considered assumption due to the fact that you assume portions of the contract, including or more specifically the benefits. And since you did, you now have accepted the entire agreement. We're talking trademark here. We're not talking a latte. We're not talking all this other shit. We're talking an asset that has IP valuation, an asset that can be appraised, and an asset that can also be used as a collateral, or it can also be used to pay off even a bankruptcy. It is a very fluid asset in the commercial scheme of things. Its only existence is to mark the commerce and the origins and quality that come from those origins.
Sure.
AKA Batman symbol, AKA tramp stamp. Huh? My logo goes there.
Almost like an address.
It lets you know that these sneakers are worth a damn, that this shirt is worth a damn, that this service is worth a damn. It has a reputation.
Huh.
So, all right, hold on, give me 1 second. All right, yep. So, that's that. Wow, what an outstanding class. Any questions?
There's some things like where it says avoid equivocation, things like that. All right, it says where it says what describe what can be arbitrated. Avoid equivocation. What does that mean?
Okay. What it means is that you have to be specific and not leave up to argument whatever the hell you are trying to get arbitrated. That means say it. That's all that means. Say it. And devoid of misunderstanding for lack of saying it. What say you? Huh? What say you?
Just be specific.
Yeah. Does that make sense or no?
Makes
Yeah,
sense.
All right. So in logic, equivocation is an informal fallacy resulting from the use of a particular word, expression in multiple sense within an argument. So, okay, it is a type of ambiguity that stems from a phrase having two or more distinct meanings. So my plain English language makes more sense now there, Devin? Because I know Kiara gets it.
That makes much more
Say it. Don't be mistaken. Be specific. That makes sense. It does. Good. So when I'm telling somebody, hey, look, I'm going to give you a licensing agreement to go ahead and destroy all the infringing articles. I'm not going to come after you, not going to sue, not going to nothing, because whatever, man, because you're unjustly fucking using my shit and you're getting money, and normally that's a trademark infringement, but we got an alternative dispute resolution. And then I take that cease and desist and I turn that into his ability to continue his job, right? Because they always have safety valves on letting the issue go. Correct or incorrect?
correct. So you're almost making him a trustee in a way.
That's right, under that licensing agreement, and that's what you're going to enforce.
Yeah.
So why would we need mediation when we already mediated it
Okay.
and pursued even the social compact at that moment? Now you got some people that go, no, I don't see it, and it works. Do you know what I mean? It works. Let me give you an example of something. Arbitration is four corners, right? Right?
Yes.
All right. Anybody here ever seen the infamous, notorious Judge Judy? Yes or no? Anybody ever seen her?
Plenty.
Her show?
Yeah.
All right. So let me give you an example of something. So there was a dad, right? And just so you know, those court TV courts are arbitration. Who here didn't know that they're arbitration? Who here didn't know that the court judges that you see on TV, every one of those tribunals are arbitration, and that some of those parties are not even real judges, they're just arbiters, and that's why they sit as judges, but they're licensed practicing attorneys. Who here didn't know that?
Here, Mommy.
I didn't know.
All right. So here's the deal. The bottom line is this. Judge Judy was talking to this man and this woman. Okay. And the woman was saying that I wanted to kick him out of my house because she was suing for damages. I wanted to kick him out of my house. But he decided to dress my daughter up and bring her with him. And I didn't want my daughter to leave. Not at no 1 a.m. And what did Judge Judy say? Judge Judy said, I don't know where you think this are, but being a father, you're not a second-class citizen. You are allowed to take that. He's allowed just as much as you. Do you have a protective order, a restraining order in between the two of you? She said, no. Okay, so there's no violence, there's no none of that, but because you decided to kick him out, now he doesn't have access to his child? I don't know what part of America you come from, but this is America. And he said, and I don't care what a lot of judges or other attorneys say. They got it wrong. In this court, fathers are not second-class citizens. Told that woman to her face. I'll send you guys the video through Telegram. Now, why do I raise that? Because inside of those courts, right, they are applying substantive law, but it's almost like a shotgun proceeding on reason. Do you see how fast most of those cases end?
Yeah.
Anybody here not see how fast those cases end?
In the course of one TV show.
That's right. And the reason why is because it's not predicated on politics. It's predicated on building an agreement. So the purview is very different. That's why when the parties come in there and they try to bring in extra parole evidence of interpretation outside of what can I quantify? So which means that those judges are only looking at what's quantifiable, not looking at their hearts. Does that make sense or not?
Mhm.
So for example, if you speak to me, right? If you speak to me and you say, hey, look, I need to know how to waive sovereign immunity. I can only quantify what would waive sovereign immunity, not your opinion. Does that make sense? So the way that the judges are listening to them is about building an agreement. And the only thing that those judges can do is agree with the law. Does that make sense? As it stands. Does that make sense?
Yeah, because if you had a jury, they could be looking at the emotional aspects, or if you had a bench trial, you would have some
Right.
political.
Well,
crap
it's
getting mixed in.
it's kind of a bench trial, but in one day, it's arbitration.
And it was an arbitrator as well, so it's not like, you know, their political position or their colleagues are going to be.
Right. That's right. And that's what makes arbitration
Like, hey,
the
you're messing
dark
up our bread and butter
closet.
because it's family law.
The dark closet that doesn't give them the wide lateral room to just bitch, moan, and complain. Well, I don't feel safe. And they're just gonna look at him and go, "You're out of your mind." The law doesn't. What? There's no.
Real talk.
You know what I mean? And it's over.
Oh yeah.
Dead. Death. Argument. Murdered right in front of cameras. Dead. So that's literally what happens at arbitration. You might try to bring up parole evidence, but the law is now written down in a contract and agreed to beforehand.
Right.
So it's very summary. The proceedings are summary. Does that make sense? Or nobody understands?
We already had an agreement beforehand. You're in breach.
That's right. That's right. And so when it comes to your contract and how the proceedings are going to go, which in arbitration, you are allowed to control. Then it becomes a situation of, did you inform the party prior to in your agreement? Does that make sense?
Yeah.
Now, what happens if a party tries to wiggle worm their way out of that agreement? What happens to them and their ego by presenting facts that have nothing to do with the four corners?
And deflate them.
Huh?
And pop their bubble.
Yeah, they're gonna pop their bubble. They're gonna give their wishes the Jesus beating from hell. Period. They're gonna be like, that doesn't exist in the construct of this. Goodbye. Whereas in a courtroom, people could try to construct shit, right?
Right. We're here to talk about the agreement,
That's right.
not your
That's right.
opinion, not your feelings.
Yeah, and then they will meet the circle of life faster than the guy who thrives from understanding his environment or her environment. Meaning they will give them a dirt nap to all their arguments immediately because it's all encased in those four corners of that agreement. The only thing that they will not allow is what is legally indefensible. And so arbiters are very keen on knowing what is legally indefensible. Like through arbitration, can you waive the sovereign immunity of a state?
Yeah.
Yes. Is the state subject to assumption due to veil piercing of the use of trademark?
Sure.
Yes. Because there's a veil piercing statutorily and a veil piercing coming from the Supreme Court. All right. So that concludes class today. Let's cut this recording off.
Oh, real quick, you said legally indefensible. Would that mean like, say the
Like, you're not gonna have a contract for picking and human trafficking, fucking women, where you're standing there whipping them like they're slaves, the same way they used to do pre-14th Amendment.
Okay, what I will say in the case of like waiving sovereign immunity, you can't say, well, you know, that this contract, there's no way out of it. You just waive it no matter what. But the state could come in and say, well, no, we didn't do it willfully.
No, because of assumption and veil piercing being a control on the courts from the Supreme Court. Allen v. Cooper, and also 15 U.S.C. 1122, in which in Allen v. Cooper, what did they say? They said Congress does have a limited capacity to abrogate due to the statute of 15 U.S.C. 1122, right? Or any of the other statutes of waiver of sovereign immunity. So there were more than one statute that they were addressing in that case. A lot of people will read it and think it's copyright, it's just copyright, and not read the legal opinion, which was saying that, okay, this case might have came under the guise of copyright, but we are going to address the Congress's potential to abrogate state sovereign immunity when they legislate, and it can only be met. And that means it goes for all of the statutes that say waiver of sovereign immunity. Okay, Congress can legislate it and they put it into context, but only under these two prongs, which are willful and not enough adequate state remedy, meaning the state refuses to acknowledge that there's a waiver of sovereign immunity, and therefore they're not allowing you to sue them in their courts, which is why at the federal level, you get to give the enemy big dick energy. Does that make sense? Huh?
Yeah, I mean, you got to take this.
But yeah, you gotta take it. Federal government says that you state motherfuckers want to hide. It's okay. We're the ones that are gonna have to make sure and ensure that the property right is fucking, you know, hey, it's acknowledged under Congress. All that shit. We're the checks and balances to states acting stupid, trying to hide behind the 11th Amendment. No. 15 U.S.C. section 1122, subsection B says, we ain't listening to your 11th Amendment argument, ass. Huh? You see what I'm saying? We will enforce. Does that make sense?
Yeah.
All right. All right, let's turn this video off before I say some more crazy stuff, because it's getting to the end of class and I'm just like, what?